Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. We're going to talk today about an incredibly scary lawsuit, one that we thought was dead but has since been revived. We haven't yet had a chance to geek out on it. I've been through the pleadings a bunch of times. It is a very convoluted subject, and I didn't know how I could do this in less than a 30-minute video, but we're going to try it today. This is another lawsuit in a long line of lawsuits that when people do illegal things with otherwise legal products, the responsibility for all of that bad, nefarious activity lies upon with the manufacturer, of course, right? You're seeing this with Glock switches. The problem is not the people who make the Glock switches and the people who use the Glock switches. No. The problem is the people who make the Glocks. You can't really make this stuff up. This is a case, though, that actually has far greater implications. It's a case that is literally meant to sue the American firearm industry into insolvency. It is a lawsuit that's brought by a foreign government and likely being persuaded by our government. It's scary for a couple of reasons. Number one, like I mentioned, the potential damage here is enormous. And number two, when you begin to see the mental gymnastics that the court did to make sure that this dead lawsuit was actually alive again, it's going to have you really, really scared. So today, let's slow it all down. Let's try to get you educated, and let's talk about how Mexico is trying to end your Second Amendment rights. Okay, so the suit we're talking about today is a case called United States of Mexico versus Smith & Wesson et al. And as you know, et al. Means there's a whole bunch of people being sued. And who is included in this lawsuit? Who is Mexico suing? Mexico is suing, obviously, Smith & Wesson, as well as Barrett, Beretta, Glock, Sturm Ruger, Interstate Arms, and Colt Manufacturing, as well as other holding companies. Now, this lawsuit was brought in the United States District Court for the District of Massachusetts, which actually threw the lawsuit out because they said, hey, listen, you can't really establish that there's any illegality here. There's what we don't call proximate cause, and we'll get to that in this video. And you haven't really established a claim of action. In addition to that, there is a piece of legislation known as the Protection of Lawful Commerce in Arms Act, or the PLCAA, which is a piece of legislation which actually keeps firearm manufacturers from being sued because idiots do terrible things with otherwise lawful products. It's tantamount to having the ability to not sue Ford because a drunk driver killed somebody while driving a Ford. Now, just so you understand the importance of the PLCAA to this litigation, please understand that this is what it claims to do. The Protection of Lawful Commerce Act, PLCAA, is a U.S. law passed in 2005 that protects firearms manufacturers and dealers from being held liable when crimes have been committed with their products. Both arms manufacturers and dealers can still be held liable for damages resulting from defective products, breach of contract, criminal misconduct, and other actions for which they are directly responsible. However, they may be held liable for negligent entrustment if it is found that they had reason to believe a firearm was intended for use in a crime. And I want you to pay attention to that last little thing, because that's the hook here, okay? Now, what happened is that after the United States District Court for the District of Massachusetts said, no, there's no lawsuit here, and they threw it out, Mexico appealed. Mexico appealed to the United States Court of Appeals First Circuit. A 3-judge panel has now found, no problem. Actually, this lawsuit should continue. And they have revived this lawsuit and now sent it back down to the trial court for further findings. Now, you sit there and you wonder, well, what exactly is Mexico's beef? Because the Court of Appeals specifically stated, Mexico has strict gun laws that make it virtually impossible for criminals to obtain firearms legally sourced in the country. It has just one gun store in the entire nation and issues fewer than 50 gun permits a year. Despite these strong domestic regulations, Mexico has the third most gun-related deaths in the world. Okay, so you have really, really strict gun laws. You basically have no access to firearms anywhere in your country, and yet you're third in the world for gun fatalities. So once again, why do we have a lawsuit? Well, according to the Court of Appeals, In an attempt to redress the harms, Mexico brought this lawsuit in federal district court in Massachusetts, seeking both damages and injunctive relief. Combined, defendants produced more than 68% of the U.S. guns trafficked into Mexico, which comes out to between 342,000 and 597,000 guns each year. Mexico alleges that defendants know that their guns are trafficked into Mexico and make deliberate design, marketing, and distribution choices to retain and grow that illegal market and the substantial profits that it produces. Okay, are you following so far what the allegations are? Oh wait, they get a little bit more crazy because it also includes Mexico alleges that one way defendants deliberately facilitate gun trafficking into Mexico is by designing their guns as military-style weapons, knowing that such weapons are particularly sought after by the drug cartels in Mexico. For instance, defendants make assault rifles with high rates of fire, low recoil, and the capacity to hold large amounts of ammunition. So the problem is not that Mexico is essentially engaged in warfare with their cartels. No. The problem is that American firearms manufacturers are making firearms that can be used by the cartels. Where is the connection? But don't worry, because the court's going to get there. So we're trying to figure out now how people making firearms in the United States completely lawfully, all within the requirements of federal and state law, and then distributing these products lawfully are somehow or another complicit in this criminal enterprise. Well, according to the Court of Appeals, they're complicit this way. Guns flow from this distribution system into Mexico in multiple ways. The most common method of trafficking is through straw sales. Oh, you mean illegal activity? Often straw sales occur in circumstances that clearly indicate to the dealer that the transaction is a straw sale and could be prevented if defendants required their dealers to be well trained and follow the law. That's right. If the manufacturers required the FFLs to follow the law. Oh, wait a second. They are required to follow the law. And who's directly responsible for training them that? Well, that's right. It's the Bureau of Alcohol, Tobacco, and Firearms. But somehow or another, this is Smith & Wesson and everybody else's fault. Now, how else do perfectly legal guns end up illegally in Mexico? Sales by non-licensed sellers at gun shows without background checks. Or in most instances, illegal activity. Many guns are often just stolen or simply lost. Illegal activity. And when you think about it, it's pretty ridiculous, isn't it? Yeah, it is. And that's exactly what the trial court thought when it ruled. Defendants filed multiple motions to dismiss Mexico's complaint. All defendants moved to dismiss for lack of Article 3 standing under Federal Rule of Civil Procedure 12b-1 and for failure to state a claim under Rule 12b-6. It also found that litigation of the remaining counts was barred by the PLCAA, which prohibits the filing of qualified civil liability action as defined as a civil action or proceeding against a manufacturer or seller of a qualified product for damages resulting from the criminal or unlawful misuse of a qualified product by the person or a third party in any federal or state court. Okay, now when you start reading the First Circuit's opinion, you'll come along this paragraph which reads, Mexico first contends that the PLCAA does not apply to lawsuits brought by foreign governments for harm suffered outside the United States. It raises three arguments in support of this contention. First, that applying the PLCAA to such a lawsuit is an impermissible extraterritorial application of the statute. Second, that the PLCAA's substantive terms must be interpreted to have only domestic scope. And third, of international comity, support Mexico's reading of the statute. We address each of these arguments in turn, finding them ultimately unavailing. All right, great. So even though Mexico put forth a really good faith effort with a lot of strong arguments, the court was not persuaded. The lawsuit remains dead, right? Wrong. Because then we get to this. As the title of the Protection of Lawful Commerce in Arms suggests, the statute is designed to protect only lawful commerce in arms. Where are we going with this? It contains various exceptions to ensure that it does not insulate firearm companies against lawsuits resulting from their unlawful behavior. One of those exceptions known as the predicate exception, exempts from the PLCAA's clutches an action in which a manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to the sale or marketing of the product, and the violation was a proximate cause of the harm for which relief is sought. Okay, and now what the firearms manufacturers are saying is, listen, there is no proximate cause. So we're going to have to geek out on some legal stuff here for a minute. What exactly is proximate cause? Well, according to the case law, proximate cause demands some direct relation between the injury asserted and the injurious conduct alleged. Proximate cause is commonly understood as a function of the foreseeability of the harm, although in certain contexts, foreseeability alone may be insufficient. So, for example, if you are developing a product which you know will malfunction, and a malfunction will clearly hurt a person, then that manufacturing of the product would be the proximate cause of the injury because it is foreseeable. But the question then is does a third party criminal conduct constitute a foreseeable act? Well, unfortunately, according to the Court of Appeals, it does. And this is the troubling way that the court broke it down. Mexico's claim of proximate cause is straightforward. Defendants aid and abet the trafficking of guns to the Mexican drug cartels, and this trafficking has foreseeably required the Mexican government to incur significant costs in response to the increased threats and violence accompanying drug cartels armed with an arsenal of military-grade weapons. The existence of the drug cartels and all that, that's not the problem. The problem is they're arming themselves with American-made firearms, which of course they obtained illegally. Now, this is what the firearms manufacturers claim, however. Defendants attempt to complicate this causal theory. They maintain that the chain of causation actually has 8 steps. 1, manufacturers sell guns to distributors. 2, distributors sell the guns to dealers. 3, dealers sell the guns to buyers with illegal intentions. 4, those buyers sell the guns to smugglers or smuggle them into Mexico themselves. 5, the cartels buy the guns. 6, the cartels use the guns. 7, the cartel's use of guns injures people and property in Mexico. And 8, the Mexican government suffers derivative financial harm for those injuries. But the court believes that there are at least 2 fatal flaws to this argument. What is that? Here, the violation that the defendants allegedly aid and abet occurs when the dealer knowingly violates the law in selling guns intended for cartels. That's right. The manufacturer would be on the hook for some illegal activity of a third-party vendor, or what we call FFLs. The court also says, viewed in this light, the relevant chain of causation starts at step 3 of the defendant's list. And from that point, the Mexican government's expenditure of funds to parry the cartels is a foreseeable and direct consequence. And I want you to understand that this argument is basically saying that the foreseeability of this action is produced by the manufacturers engaging in manufacturing. That is the ludicrous nature of this argument. But you need to understand, America, that right now the First Circuit has said, hey, this is a good lawsuit, full steam ahead. Now, this is being appealed right now currently to the United States Supreme Court for emergency review. There is a bunch of amicus briefs that are being thrown in on it, including one from the Firearms Policy Coalition, as well as one from a bunch of attorneys generals around the United States. We're actually going to geek out on those and get another video done on this. But I want you to pay very careful attention to this lawsuit, because when that pesky little thing like the United States Constitution gets in the way of this particular presidential administration of disarming Americans, maybe they're just going to ask for the assistance of foreign governments. The case, once again, is United States of Mexico versus Smith & Wesson et al. We're going to link it up down below so that all of you can geek out on it for yourself. If you guys got ideas for videos we should be doing here at Washington Gun Law, click on that link right there. Let us know. Some of the best ideas we ever had weren't really our ideas. If you need to ask Washington Gun Law any questions about this or anything else related to what's left of our Second Amendment rights, our contact information is down below in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.